United States, the great state of Florida, and this honorable court.
Please be seated. We have one case on the docket scheduled for oral argument this afternoon, the case of BAM Trading Services, Inc. versus State of Florida Office of Financial Regulation. Counsel, ready to proceed? Counsel, I will allocate 20 minutes per side for this oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor, I would like to reserve 5 minutes.
So noted, Madam Clerk.
Good afternoon, may it please the court. My name is Drew Parker and I'm with the Rady Law Firm. I'm here on behalf of the petitioner, BAM Trading Services, Inc. This case deals with an emergency suspension order issued by the Office of Financial Regulation, which summarily suspended BAM Trading's license as a money transmitter and ordered BAM Trading to cease and desist from all money transmitting business within the state of Florida. BAM Trading is respectfully requesting this court to quash the emergency suspension order on 3 grounds. First, the order fails to satisfy the requirements of 120.60(6) in this court's case law dealing with emergency suspension orders. Second, the notice of rights that was provided to BAM Trading is deficient and fails to provide essential due process rights to it. And the third is that the ESO actually causes, rather than remedies, irreparable harm to Florida citizens.
On that point, in your petition, which I'm not sure it should be a petition, we can talk about that a little later, but you said that the state is attempting to force BAM to terminate 170,000 plus accounts?
Yes, Your Honor, that's correct.
So if that had occurred in, I believe it was December the complaint was filed?
So I have not been a part of the conversation. There's been conversations that...
No, when was the administrative complaint filed?
The administrative complaint was filed...
December or November, correct?
December, yes, Your Honor.
And had those accounts been terminated in December or November, what kind of damage would have potentially been done to those account holders in the state of Florida?
Well, those roughly 170 plus thousand account holders hold about 150 million in digital fiat. The forced sale would have required them to experience unintended tax consequences if they made a profit. They could have potentially have suffered.
So I mean, my understanding is their accounts would have been terminated and all their cryptocurrency would have been required to be sold, correct?
That's correct.
So how was the market value of cryptocurrency in December compared to today?
I'm not sure I know the answer to that, but I could...
But your allegation is that by requiring that termination, because of the volatility of the cryptocurrency market, those account holders could have lost substantial sums of money, right?
They could have lost or could have...
Let's say, for example, let's say just hypothetically, had the cryptocurrency market doubled since then, that would have been 100% loss if those accounts were terminated in December, right?
That's correct. There's also cost associated with the transaction, with the liquidation of the assets, as well as costs associated with moving if they desired to purchase those assets on another platform.
Before I ask about the controlling shareholder, can you tell me how you pronounce his last name?
Sal.
Sal. Okay. So is there any dispute that Mr. Sal meets, I mean, technically at least one of the criteria under 560.114 1 OP or Q?
Yes, Your Honor.
I mean, he's convicted of one of those.
He has pled guilty to a crime, but we dispute whether it's a crime that involves moral turpitude, fraud, or dishonest dealing.
Okay. Let's assume, though, that he was. Or let's assume that the crime to which he pleaded guilty meets that definition. Is it your position, at least in part, or your argument in part, that the ESO is, doesn't comply with the law because it doesn't provide for sufficient findings of, that are required in a 12060? Is that part of it?
Yes, Your Honor, it is. I think that there's really, if you boil it down to the three requirements, there would need to be a danger that's established.
Well,
That
I
is-
mean, the complaint, the federal complaint, criminal complaint asserts that by violating the Money Banking Secrecy Act, Mr. Zhao purposely allowed transactions that included transactions for exchanges from Iran, Cuba, and as I recall from the respondent's brief, transactions involving Hamas and other terrorist-type related activities. Is that correct?
I believe so.
So basically, what we're looking at is a complaint where Mr. Zhao pleaded guilty. I assume sentencing has not yet occurred. I do note that the agreement is that he pay a $50 million fine,
That's correct, Your Honor.
and that those transactions were purposely hidden from view from the federal government, right? They did not use the Know Your Customer legal, they did not meet those requirements. They did not require, in fact, they didn't require anything, right? Just an email address.
I believe that's correct, Your Honor, but I'm not intimately familiar with.
Well, that's correct. It's part of the federal plea agreement,
Right.
so.
Back to my question.
Yes,
though,
Your Honor. So there were three things that are needed. One is a danger to be remedied, the need to remedy it, and that the remedy be fair.
Sure. Right, and it's the
So-
fairness
so-
part that I wanted to ask about. So, I mean, the starting point is, yes, the OFR has the authority to start with this, the assessment about whether to do an emergency suspension, because it's listed as, potentially the public danger, if it meets one of those criteria. But that's only the starting point of the analysis, right? I mean, 120, you go to 12060, and there's other things that the office is supposed to do.
That's correct, Your Honor.
And so before you get further in that, and Judge Thomas had alluded at the beginning, can you address, hopefully you're prepared to address this part. You argue as if this is a cert review, and your opponent argues it as if it's 12068 sub 7 and sub 8, and which is a typical legal, criteria that we're supposed to be looking at before we set aside an administrative order. I'm assuming you're just following what this court has said or suggested in the past about a petition for a review of non-final agency action being just like cert review.
That's correct.
Okay. Let's assume that there's no statutory basis for that position. And we're actually under 12068, which is the statutory authorization for us to engage in judicial review,
Right.
which I think we are. What should be the standard of review that we should be applying here? Forget cert for a second and just, we're in an administrative proceeding, we're reviewing administrative action.
So I think that initially this court's jurisdiction emanates from Section 5, 4B2, which says that the power of the court is direct review of administrative actions prescribed by general law, and then, of course, 12068 says that provides for that. I think that it is, Your Honor, I'm not sure that I believe it would be de novo, but I'm not sure, and I could provide additional briefing.
Well, the
if you
statute
desire.
says that if a non-final action by the agency cannot be remedied without judicial review, without judicial intervention, if you will, you're entitled to relief. That's what the statute says, and in fact, the statutes applicable here under 12068 and 12060 are very broad in terms of the grant of power to this court to take action should it determine the agency's complaint here it does not meet 12060 sub 6, which of course is your argument.
That
We don't
is-
blame you for citing our precedent regarding the standard of review being certiorari, but in fact, our court's decisions making that statement refer to a quick case from the Third District Court of Appeal that refer to a case back from this court that refers to a committee note by the Rules of Appellate Procedure Committee that actually seems to be based on nothing. So,
So, yeah, so, I mean, you're in your prior position, I'm assuming you are somewhat familiar with 12068 and
Yes,
and
Your Honor.
subsection 7 in particular. Which of the criteria, one or more of, or under subsection 7, would you have us proceed under if we're looking for a basis to set aside the ESO? Sorry, that's almost like a pop quiz in law school. I mean, there's a mention about fairness of the proceeding, if the agencies erroneously interpreted a provision of law, violation of a statutory provision,
Well, I
maybe
mean,
it's all of it.
I could just go through them if you like. I think
Sure.
that, so 7A says that there has been no hearing prior to agency action, and the reviewing court finds the validity of the action depends on disputed facts. And I would say that we have disputed facts that are at issue in this case, particularly the issue of whether Mr. Zile's crime is one that involves moral turpitude, fraud, or dishonest dealings.
Counselor, is it your
that-
position that an ESO issued pursuant to section 560.114(2) must also satisfy the requirements of section 120.66?
That's correct, Your Honor.
Why does the ESO issued in this case per se satisfy the requirements of 120.66?
Because 120.60(6) requires not only that there be an emergency, but that the emergency order is designed to stop that emergency, and that the method of stopping it is only used, and that is fair under the circumstances. And in this case, there's no allegations that the crimes that Mr. Ziles pled to, that BAM Trading was involved in them. And Mr. Ziles' conduct has stopped. By the ESO's own terms, it stopped a year before it was issued.
You may have somewhat addressed this, but why aren't paragraphs 11 and 12A through D of the ESO sufficient to satisfy the requirements of section 120.66C?
Because those facts only go to whether there is an emergency. That they go to the danger that's trying to be addressed by the ESO. There's no discussion in the ESO.
Isn't the implied danger, they have not specifically alleged it, as far as I can read from scouring the record and the complaint. It seems to me that the implied danger that lurks beneath the administrative complaint, not to use a pejorative verb, is that your company will continue to allow transactions in the state of Florida where the Know Your Customer forms are not properly filed with the federal government, that somehow there's a violation of federal law ongoing. Now, the office did not allege this, does not assert that I saw. It simply asserts that, as you note, that Mr. Zile engaged in that activity, the company or parent company did, and as you note, that ended in April 2022. So isn't that the crux in the heart of this case? There's an implication in the complaint that allowing these accounts in Florida is allowing transactions involving terrorist activity, transactions involving Cuba, transactions involving Iran.
There's no allegations
I know
related
there's
to
no
any
allegation.
wrongdoing by BAM Trading. And
In fact,
an
zero.
implication by entry of the emergency suspension order would be insufficient to hold, for this court to uphold it, because the allegations in an emergency suspension have to be on the face
I understand
of the
that.
order.
I understand that.
Who is the license issued to?
BAM Trading Services, Inc.
Not Mr. Zhao?
That's correct.
And that's one of your points, is they're suspending a license regarding a corporation or business entity that was not involved in the wrongdoing, not to dispute the fact that the principal of that entity was engaged in the wrongdoing. But your argument is that the office should be separating that out and being more specific about it?
Right, if they had a problem with Mr. Zhao, they could have issued a cease and desist to Mr. Zhao to be involved in BAM Trading Services, or they could have or issued an order of removal directing BAM Trading to remove him as
Now, it's BAM Trading Company doing business as Binance, right?
Binance.us.
Right. So Mr. Zhao, in fact, is appointed a proxy from
He-
my review of the appendix.
Well, I would say that's the appendix of OFR, and I'm not
Correct.
sure whether those are appropriate.
But I mean,
but-
they state in their response that Mr. Zhao is still the controlling shareholder. Is that true?
I would say statutorily, that is true because of his negotiations related to his criminal charges and federal issues. He's not able to sell his interest in BAM Trading, but he has issued a proxy whereby he is no longer involved in the business.
What other less harmful remedies were available to OFR other than the ESO issued in this case?
Well, I mentioned one would be a cease and desist to Mr. Zhao directly. One would be an order of removal to BAM Trading. Another would be an ESO that would be limited in time for OFR to come in to see whether, in fact, the issues that existed at Binance exist at BAM Trading. I mean, there's no allegations that the issues with failure to implement a proper anti-money laundering program exist in BAM Trading.
You're into your rebuttal time, counsel.
Thank you, Your Honor. I'll just say that there are three independent statutory grounds which would each alone be sufficient for this court to quash the ESO, and we would respectfully request the court do that. Thank you, Your Honor.
And thank you, counsel.
Good afternoon, Your Honors. May it please the court. My name is Brandon Greenberg, and I represent the Florida Office of Financial Regulation, who's responding to BAM Trading's petition. Your Honors, this case is about applying the plain text of a regulatory statute which provides specific authority to impose a summary suspension under particular and narrow circumstances that have been deemed by the legislature to pose an immediate serious danger to the public health, safety, and welfare in a way that is harmonized with the more generalized statutory authority that all agencies have.
Under section 120.66, what was the factual basis for the purported immediate danger to the public by the petitioner?
I'm sorry,
What
Judge
was the
Lewis.
basis for the immediate danger under section 120.66 by the petitioner to the public?
Yes, Your Honor. So the factual basis that has established the immediate serious danger that's set forth in the ESO is that there is a natural person who is required to be on the licensee's application who's been criminally charged or arrested for a state or federal crime or felony punishable by over 1 year of imprisonment that involves fraud or moral turpitude or dishonest dealing. Now, I understand that it is the petitioner's argument that a material fact is in dispute with regard to whether that crime involves fraud or moral turpitude or dishonest dealing. However, it is the OFR's position this is a question of law, which is resolved by the agency in the ESO based on the underlying factual basis set forth in the findings of fact, which I will point out has been fully admitted to by Mr. Zhao, the control person, in his plea agreement with the federal government, which neither he nor the petitioner is legally allowed to contradict either publicly or in subsequent litigation. These are admitted facts as a matter of public record. They're admitted to the agency through the petitioner's disclosures as required by Chapter 560, and there's no material fact in dispute with regard to fraud, moral turpitude, or dishonest dealing, because as the case law in Florida points out, that is a ultimate question of law.
But that just gets you across the threshold to authorize the office to even consider an emergency suspension order, a summary emergency suspension order, so summary being, you can do it without any hearing at all. It seems to me that in such extreme circumstances that more, and I'm not just making this up, it sounds like it's actually contained in the statute, that more is required of the office before it actually does issue an order. So let's assume that there's no dispute that there's a immediate public danger that meets the criteria under the statute. It's moral turpitude, there's a conviction to that effect. Now you're in the world of having to craft an appropriate ESO that's narrowly tailored to meet that danger. Don't you think that there's more required of the office in its order to set out why this is a fair approach, what the office has considered more narrow remedies, as opposed to just saying, okay, we win, or we can issue this order because Mr. Zhao was convicted of this crime?
Your Honor, if I understand the question correctly, my response would be that the ESOs that have been issued generally under 12066 that this court has reviewed in cases like NAF, cited by the petitioner, or Biomed, they did not involve specific ESOs issued under very particular legislatively drafted circumstances. Those ESOs involved an agency's general authority to make its own independent findings of an immediate serious danger. And the courts, rightfully, have held them to these specific requirements that it must be narrowly tailored, the necessity must show up on the face of the ESO. That it's the agency's contention that the generalized ESOs are properly analyzed under this NAF test. However, in this court's precedent under Mendelssohn and Bethencourt Miranda, this court determined that no further findings of fact were required on the face of the ESO if the particular crime was set forth properly in the face of the ESO. In Bethencourt Miranda, that's what happened, and this court upheld that ESO.
So I think essentially your argument is, and I would note first off that 561.14 does cross-reference 120.60 sub 6. So I'd ask you to keep that in mind. But it seems to me that logically your argument is this. Because the legislature has specified that if a natural person required to register as part of this application is convicted of a crime, which nobody disputes here has occurred, then there's no further need to determine an immediate danger to the public. That in of itself is sufficient to shut down BAM trading, force them to terminate all 178,000 Florida accounts, which had they been terminated in November, December, those accounts would have been worth X. They might be worth 2X now, They might be worth half X. That market is quite volatile. But regardless, let's assume for the sake of a hypothetical that those accounts would have lost money, that the value of the generalized cryptocurrency exchange or cryptocurrency market is higher today than it was when the ESO was issued. So just assume hypothetically that 100,000 accounts would have lost a significant sum, I assume, based on the total value, that's legally irrelevant here.
Judge Thomas, I would argue that the premise that this question is based upon, which the petitioner has advanced, is flawed.
All right.
Because the
Did your account did your ESO, would it have required the termination of those accounts?
No. We required that the funds be moved off of the Binance platform and moved someplace else. Nobody
To another
required.
business entity.
I'm sorry?
To another business entity. To another business entity that is not BAM, right?
Sure, to another business entity. Look, the bottom line is that the crime was committed and admitted to by the petitioner's control person. The OFR did not put the company in this position, he did. So the attempts of the petition.
But he's not the company.
He's not the company, but his crimes are directly related to the same business that the company is in while he was in control of the petitioner.
And back to my hypothetical, if those accounts have to be terminated or, quote, moved, those holdings have to be sold for cash. That cash has to be reinvested in another platform. I don't recall from your response, which I'll call your answer brief, which was quite well written, I might add, that you made a strong point that, well, nobody really has to suffer any losses here as a result of the ESO, or there's no danger there. I read your brief to say it doesn't matter. That's their fault. I understand the logic there. That's their fault. He pleaded guilty to this crime. That is specified in the statute. Ipso facto, there's an immediate danger to the public, and we can shut BAM trading down. That's the bottom line of the argument, isn't it?
Yes, Your Honor, and to build on that, I would say that any licensee who gets suspended could make that same argument,
I understand.
right?
But I'm asking you, is that,
Go ahead.
I'm asking you, isn't that the logical bottom line of your argument? That because subparagraph O specifies if you've been convicted of this crime, and I just tend, for purposes of oral argument, tend to agree with you that arguing that that wasn't a crime of moral turpitude or dishonesty is a stretch when you read that plea agreement. So, but because of that, ipso facto, you don't have to prove anything else. You don't have to prove any specific danger to the public. That's your argument, right?
I apologize, Your Honor.
That's okay.
The danger exists per se as a matter of law, as the legislature has described this narrow circumstance. And I would just point out that, just as a point of clarification, the criminal charge itself, not even a guilty plea or a no contest plea, but just the charge establishes, according to the legislature, an immediate and serious danger. So in this case, we have a guilty plea that immediately followed the criminal charge.
I understand, but the logic has to be, your logic has to be that even though this because I've read your complaint, I've read your appendix, I've read the plea agreement, your logical argument is it doesn't matter if this activity stopped in 2022. He pleaded guilty. He's out of the picture, so to speak. He's appointed a proxy. I get all of this from your own appendix. He's appointed a proxy. That behavior is finished. But legally, your view is, the office's view is, it doesn't matter. Because that's in the statute, the 178,000 people in Florida that have these accounts, their accounts can be terminated, moved, however you want to describe that process. I don't recall your brief going into detail there. Then that is sufficient as a matter of law under 12060 sub 6.
It is, Your Honor. Mr. Zhao remains a control person in control of the petitioner. The proxy that he's executed is a revocable proxy. I'm not sure if petitioner's counsel mentioned that point, but it is revocable at any time. His stature in the industry is massive. He could tweet and he could influence the market activity. I mean,
But you're not, you made, and you certainly didn't, the office didn't make any such allegation that there's a danger that he's going to somehow persuade BAM Trading Company to stop complying with the Know Your Customer federal requirements, stop complying with other federal law. He's going to whisper in their ear like he did before, which he admitted to. It's better to get forgiveness than to ask permission. I mean, it's an extensive plea agreement, and he's facing up to 10 years imprisonment.
Yes, Your Honor.
And the U.S. Attorney has stated they are not agreeing to seek a below-the-guideline sentence. So it's a serious criminal case. But your complaint doesn't make any allegation that that kind of behavior is going to continue with BAM Trading in the state of Florida, because your logical argument is we don't have to. Because of the legislative specification of this criminal charge, we can shut this account down without a 12057-1 hearing.
Your Honor, I would say that is a fair characterization of our position.
And I understand, again, anyone who reads that plea agreement and sees what the activity was and sees that Mr. Zal's agreed to pay a $50 million fine will understand immediately it's very serious business.
Well, the legislature has designed not just the narrow circumstances creating the immediate serious danger, or recognizing it rather, but also the fair procedure under the circumstances. Now, in 12060...
But they haven't, only in 120.60 subsection 6, if we could get back to the statute before the end of this argument.
Yes, Your Honor.
The statute requires more of you. So, okay, the public danger is there, but that's not the end of your analysis, your responsibility as the office. Don't you have to consider fair procedures and narrowly tailor the order to meet the danger? I mean, isn't that an expectation in 12060 subsection 6?
Your
Or
Honor,
do you think that you're exempt from that under this particular statute?
rather than characterizing it as an exemption, Your Honor, our position is that the two provisions are harmonized because, A, as Judge Thomas pointed out, there is a reference in 561.14.2 that says pursuant to 12066, which could also mean as authorized by 12066. The legislature has fully aware of 12066 prior to passing this bill and has considered what type of procedure out of summary suspension, summary restriction, summary limitations on the license, that a summary suspension is the appropriate and fair procedure that is necessary under the circumstances.
Counsel, although the ASO is directed to the petitioner, would it also adversely affect the 170,000 Floridians referenced by the petitioner?
Judge Lewis, the petition raises these sort of speculative or merely potential harms that it has not really fleshed out, but this is the improper policy consideration. The proper policy consideration is the state of Florida, the public as a whole, and the petitioner has not, instead of considering that and what these AML laws are required to do, which is to protect the public from organized crime, from terror financing, from dark web purchases of child pornography.
But your complaint doesn't allege any of that. And going back to my colleague's question regarding the statute, are you arguing that the phrase in the statute that says pursuant to 12060 subparagraph 6, we don't have to comply with anything beyond finding that a natural person required to be registered has been convicted of a crime such as occurred here? Other than give a 12057-2 hearing where you're not allowed to dispute any facts? Which basically here, I don't see any facts that are to be disputed, in a sense, because you haven't alleged any facts, other than the criminal conviction.
Or to put it in a different way, look, there is actually no real procedure set out in 12060 subsection 6. What it does is it specifies what you have to do if you decide otherwise that you're going to summarily suspend a license. And it talks about making findings, not just about whether there's a public danger, but how this action actually is fair under the circumstances. Where is that part in the ESO? Where is that consideration set out in the office's ESO?
The office's understanding of that provision is that the procedure, meaning the ESO, which is the procedure, the suspension, and, as the legislature requires, a agency proceeding that shall be conducted by the agency's commissioner or a designee. The
But-
ESO was drafted with that in mind. I apologize.
No, you go ahead and finish your thought.
The ESO was drafted with the legislative plain text in mind to follow that and therefore satisfy 12066, because the legislature must be presumed to be aware of 12066 in deciding that the appropriate and fair procedure is a summary suspension.
But isn't a more fair, harmonious reading of the two statutes, especially given when as I recall, the paragraph begins pursuant to 12060 sub 6, that the legislature intended that this ground that you allege here, for example, can be a ground for termination of a licensee, suspension of a business, but you still must comply with the provisions of 12060 sub 6. In other words, the allegation, which is not disputed, that Mr. Zhao has pleaded guilty to this offense, can be the basis of an order, suspending or a more narrowly tailored order, as long as the agency complies with 12060.60 subparagraph 6. Isn't that the better harmonious reading?
I think that a fair reading that does harmonize both of them is to understand that the case law around narrow tailoring.
I'm not asking about the case law. I'm asking about the statute.
Okay. Well, our position is that the harmonized reading is that if the two requirements that are written into 561.14.2 are satisfied, that authorizes the ESO
So what you're really
procedure
arguing is if the
120.
two criteria are satisfied under 560.114, we don't have to meet any of the provisions of 12060 subparagraph 6. That's your argument, right?
That is the argument that was relied on as the rationale in Bethencourt Miranda.
Again,
and
I'm not asking about case law.
No, I understand.
That's your argument, that
Yes,
that
that
is
is the
how the
argument.
statute
Yes,
has
Your
to be
Honor.
interpreted.
Yes.
Logically, that has to be.
Does the office have other options to protect the public short of this suspension of BAM's license?
Judge Tannenbaum, our position is that if the office wanted to impose a summary procedure that was not the summary suspension that the legislature called for in 561.14.2, then it would have to justify that to a reviewing court under these elements that we're talking about, narrowly tailoring, necessity, because we're
does the
deviating
office-
from the legislative text.
Does the office have other tools available to it to address these circumstances? Let's pretend the summary, this total suspension of the license was not available as an option, but you had the typical other administrative tools. Do you have other controls over their license that you could have, that the office could
Yes, Your
implement?
Honor. In this case, we also have a pending administrative proceeding that's seeking to revoke the license, as we pointed out.
Well, that's okay, but that's kind of the same thing. I mean, in
Referring to
the
a cease and
interim.
desist, something like that, something of that nature?
Yeah, I mean, is there some other, obviously you've directed the BAM to do other things as well. Where's the authority to do that?
We have no authority to order him to divest his interest, if that's the suggestion of the petitioner, or to order the company to remove him. We don't have that ability to do that under the statute.
If you're so inclined.
So it's really an on-off, it's an on-off, or a, say, binary kind of question. Either it's total suspension of the license, or the office can't do anything at all under these circumstances.
Well, as I had said earlier, Judge, something short of the procedure called for by the legislature would have to be reviewed under those narrow tailoring, necessity, immediacy prongs, because we'd be deviating from what the legislature has required in that instance. They've determined what is fair, summary suspension.
Counsel, your time has expired. However, I will extend your time by an additional 3 minutes, and I will extend the petitioner's time, rebuttal time, by an additional 3 minutes. Now, going back to 120.66, counsel for petitioner presented some less harsh remedies available to OFR during his presentation, why weren't other less harmful remedies insufficient to OFR in this case?
Your Honor, well, the petitioner pointed out that or suggested rather, that the OFR could have ordered a divestiture, which was in the petition. Counsel for the petitioner pointed out today that the agency could have issued a cease and desist directly to Mr. Zhao, or an order of removal of Mr. Zhao. But at the end of the day, he's still a control person. We don't have the power to make him not a control person. Only he does, and he, so far, does not appear to be willing to not be a control person.
You're saying you have like no actual regulatory control over one of your licensees? Other than to suspend their license. That's the suspend or revoke a license. There's nothing else you can do for a licensee to police them or to protect their investors in the interim while you address a more final action.
Your Honor, short of this a temporary suspension procedure, nothing else appears to be called for by the legislature under these particular criminal circumstances that have been defined in statute.
During COVID, the governor's agencies, they were leveraging licenses all over the place to get licensees to do stuff that wasn't actually specifically provided for in statute. It sounds to me that a regulatory or policing agency like you, or like your office, I find that hard to believe that you have no leverage over your licensees.
Well,
Is that the position of the office? Is that you have one tool in your toolbox, and that is to suspend the license and put them basically, basically to freeze them out?
there may be other tools that I am, I'm not aware of at this moment, Your Honor, but in terms of the one that was decided upon, it does comply with Chapter 560 requirements in accordance with 12066. That's the agency's position.
In other words, if we have other tools, we're not going to use them. I understand. That's more a comment, not a question.
This is a very large cryptocurrency company that has a lot of business in the state of Florida, and the agency is tasked with protecting the public, consumers. The state of Florida has a lot of, let's say, at-risk investors.
Just not the investors that have accounts at BAM right now. Just everyone else.
Well, I would also point out that when the ESO was first issued, our agency's counsel was in communication with their counsel, attempting to be fair and work with them on a timeline that would work for them. However, they filed their appeal after we filed our administrative complaint, and things sort of went in that direction. But I would like to leave the court with that the agency did attempt to provide a certain time period in which the company could wind down its affairs in Florida.
Going back to our discussion concerning 120.66, Section 560.114(2) particularly references 120 in the beginning. It says pursuant to 120, right? So, in that regard, the petitioner notes in their petition that Mr. Zhao had alleged conduct occurred up to a year prior to the issuance of the ESO. Do you agree with that statement?
The admitted activity started in 2017 and ended at least by October 2022, which is about 1 year before the ESO. But if I could, Your Honor, I would point out that the ESOs in the Biomed case, in other Kaplan, other cases before this court, the court did not like that the conduct complained of was over 2 years, over 3 years before the ESO. Here we have 1 year, and it's very egregious conduct.
Again, going back to 120.66, what was the factual basis for a finding of a continuing emergency, in this case, for issuance of the ESO?
The continuing emergency? Okay. So in the Saviak case, there's an inference that may be drawn from allegations of past and recent conduct, and that inference may support finding that the harmful conduct may continue. That's this court's case law. And if we're looking at the NAF test framework for this particular ESO, there is a continuing harm because it is fair to draw that inference based on what is alleged in the ESO. There's past and recent conduct up to just 1 year ago, which is much more recent than in Biomed, than in Kaplan. Crudell, I think, was over 2 years. So I think that there is a reasonable inference that can be drawn that his continued control of this company subjects the public to further harm.
And I asked one question of the other side about standard review, so I want to just make sure I ask you the same question. I mean, I was very happy to see that your briefs argued 12068 sub 7. And is that the office's position, that the appropriate basis for review is looking at whether we have something in subsection 7 of 12068 to support setting it aside?
Yes, Judge Tannenbaum, that is in footnote 21 in our response on page 26. We, as you noted, that we have looked at that, and we haven't found that the petitioner has established any right to relief under that provision.
Right, I know you don't agree that
Sure.
any of the criteria have been met, but we should be looking at 12068
I would say
subsection
so.
7 to make that assessment.
That's fair.
You get a bonus point for that.
Thank you.
And thank you, counsel.
All right. Thank you, Your Honors.
Are you going to extend him?
In addition to 3 minutes, counsel, we'll extend your time by additional 2 minutes if you should need it.
Thank you, Your Honor. I hope not to. I hope to have the opportunity to earn a bonus point, too. I want to start off with 560.114 and the point that counsel made for OFR, that they either had to suspend the license of BAM trading or not, that they were really looking at a binary equation, yes or no. And if you look at 560.114, it says that OFR has the authority to issue a cease and desist order, issuance of a removal order, the denial, suspension, or revocation of a license, or taking other action within the authority of the office pursuant to this chapter. There were other less severe options that OFR had to choose from. And they chose the one that was the most draconian, and that is the suspension of a license. But they're only allowed to take that action when it's necessary to protect the public interest. And no one alleges that Zal's past conduct took place at BAM Trading. There's no facts to indicate that the crime for which he pled is going to continue. It doesn't allege, the ESO doesn't allege how suspending BAM's trading license is related to or remedies Zal's past conduct. It doesn't allege how suspending BAM trading license will remedy emergency created by the conduct complained of. It fails to allege any factual allegations as to any wrongdoing by BAM Trading, which is the licensee. There are no allegations that Mr. Zal committed any of the acts for which he has pleaded guilty through BAM Trading. And there's no factual allegations that BAM Trading was involved in any way in Mr. Rao or Binance Holding Ltd's actions for which they've pled guilty. And the implication is if OFR is allowed to enter an order like it's entered in this case that's conclusory and filled with innuendo and implication without stating facts, that sets a serious precedent for licensees in the state of Florida and the ability of a state agency to summarily suspend those licenses without requiring them to comply with 120.60 paren 6.
Does the office have the authority, I was kind of alluding to this before, does the office have the authority to come to your client and say, look, we don't want to suspend your license if we don't have to, but you need to do the following things. Clean your house before, or otherwise, you know what we can do. in essence, leveraging the license, which I mentioned before. It doesn't, as a
That-
regulatory agency, as the licensor of your client, don't they have a variety of, significant leverage?
Absolutely, Your Honor.
Especially considering they've already met, I know you don't agree, but let's just say that it's pretty obvious that there's a moral turpitude component of this and that maybe there's probably a public danger as specified in the statute. So they already are across the threshold and they come to you and say, look, we have the authority to issue this summary suspension order, but we won't if you do the following things. Is that totally within their authority?
Totally within their authority, yes, Your Honor.
And so the reference to 12060 subsection 6, the cross-reference, and then when you look at that provision, it seems to task the agency before they do something as drastic as this kind of, like an emergency suspension without any hearing. It seems like they're required to do some, if it were a court, like some sort of equity assessment. They have to balance everything, balance the effects, the negative effects, the need to do this, what's the danger, and carefully craft an order that meets that danger and nothing else. Is that
Absolutely, Your
mostly
Honor.
your position?
Absolutely.
And they should set this out in an order? Like
They
in
should-
writing, they should set out this analysis in an order so that someone like us, like this court, can review it to assess whether they've complied with the law.
Right. The only way that you all, as a reviewing court, can know whether the intended action or, emergency action is appropriate is if there's a factual finding made to satisfy 120.60 per N6 in this court's case law, starting with Biomed Plus. I think that it's interesting. I think we're getting way past what's in the ESO, but that Binance Holding Ltd., which is the company that the actions of Mr. Zhao relate to, that as part of everything that's taken place in the cases in federal court brought by U.S. attorneys in the SEC, is that they have not required the termination of Binance Holding Ltd. as a company. I mean, despite everything that's taken place, they can still continue to exist. But OFR, in their view, an unrelated company, because Mr. Zhao did something with another company, that's grounds for BAM Trading to no longer exist. And I think that is hard to appreciate and swallow without more factual findings to support such an assertion.
You addressed this previously, but let me ask the question again. In reference to 120.66C, the action of specific facts and reasons for finding immediate danger to public health, safety, or welfare, etc. Why does paragraphs 11 and 12A through D not satisfy the requirements of 120.66C?
Because the factual allegations that are included in the ESO really just go to the first part, and that is whether there is an immediate danger to the public, health, safety, or welfare. It fails to contain any reasons for concluding that the procedure used is fair under the circumstances, and that it's needed, that an emergency suspension order is needed.
This as opposed to something more narrow or less drastic, basically.
Yes, Your Honor. So I see that my time is about up. Thank you for your time this afternoon.
And thank you, counsels, for your respectful oral arguments this afternoon. This concludes our oral arguments for this afternoon. We are adjourned.
All rise.